Good afternoon and welcome to the Legal Hour. I'm Keith Spencer. Today we're coming from the Legal Cafe, which is at 114 Main Street in downtown Fort Worth. It's kind of a co-working spot for attorneys built by attorneys. Imagine a mobile hotspot for your whole office right next to the courthouse. It's a new concept and we're here today. And we're going to be discussing today a really broad topic called personal injury. And it covers a wide range of things. And today I'm joined by two accomplished personal injury attorneys, Kern Lewis and Anna Lee. Kern, why don't you start? Tell us a little bit about yourself and kind of describe the whole field of personal injury litigation.
All right, I'm an attorney who's been practicing for 35 years. All of it in personal injury law, and I have kind of a specialty in personal injury. Well, I'm board certified in two areas: civil trial law, which covers all of cases that will go to trial in a civil matter, and consumer and commercial law, which my interest in that was because it covers the area of products liability, which is often responsible for a lot of personal injuries. So I've been practicing personal injury law for 35 years. Personal injury deals with when someone is injured primarily as the result of the negligence of someone else. And that negligence can be in the form of a defectively designed or manufactured product, or it can be negligence in the failure to do what a reasonable person would do, is how they define it. So a car wreck, you're not driving your car reasonably. An oil field injury. Someone on the oil rig did not act reasonably and allowed you to be in a situation that was unsafe. An employer who does not furnish a reasonably safe place to work for their employees. All of those things can result in a personal injury.
Okay. And Kern, tell us a little bit, Anna, tell us a little bit about yourself and what you do.
Yeah, so I'm also a personal injury litigation attorney. I've been practicing now for 6 years, also only in the personal injury litigation department. So once the lawsuit has been filed, that's when we take it from beginning to end, and that's what I do primarily.
And all of us are actually employed by the law firm of Bailey and Gallion. And Kern, I believe you're in the office in downtown Fort Worth, and Anna, you're in the office in downtown Dallas.
That's right.
And so we've got offices everywhere. So come see us. Personal injury is one of those fields that I think people get a little bit scared of, partly because they've been injured, they can't work, and they're thinking, now I have to hire an attorney. How in the world am I going to do that? What would you tell someone who's hurt, can't work, and terrified that they don't have the money to hire an attorney?
Well, attorneys are available to you even though you don't have the money to hire one, especially in the personal injury area, because most of the work I've done over the last 35 years in that area is based on what's called a contingent fee, meaning whether or not I'm paid depends on whether or not I get you a recovery. I am compensated by a percentage of your case. And therefore, I have the same interest as you do in that if you don't win, I don't get paid. So I want to make sure that you win. So it's still possible for you to find an attorney. In fact, it would be unusual if you hired a personal injury attorney on a basis other than a contingent fee. And that's because so many times the outcome of the case is so uncertain, whether or not you're going to win, whether or not the facts are such that the other side is responsible for your injury. What is the amount of your injury? There are so many unknowns in a personal injury lawsuit. Mm-hmm. It would be really hard to make a good business decision and say, okay, I'm willing to spend X dollars out of my savings to hire an attorney to do this when you don't know if you're going to be able to have a recovery or not.
Anna, do you ever find that terrible accident happens, someone's in the hospital, and before they know it, there's an insurance adjuster in the hospital room with them?
It is possible that they want to take as much information as they can as soon as they can, and take advantage of the fact that someone is not in a position to be interviewed by an insurance adjuster, and it really puts them in a vulnerable position. And that's why it is important to hire an attorney to kind of be the protector, the representation to say, no, we're going to do this on our time, and we will come to you and we will give you a statement once, my client is ready and prepared to do so.
Well, it seems like at the hospital is a really unfair time. They may still be on meds that may have altered their perception. And if you're in the hospital right after the accident, you may not have a clue how bad your injuries are, what the prognosis is, what kind of future treatments might be needed. So what should someone do if an insurance adjuster suddenly shows up in their hotel room or their hospital room?
Turn them away. Tell them that they are not in a position to talk, and that they would rather speak to them with help.
Okay. Kern, a lot of people miss out because of statute of limitations problems. How soon after an injury do folks need to talk to an attorney, and why?
Well, the first part of that question is how soon should they consult with an attorney? And I would say as soon as possible. And there are a lot of things that an attorney can do early on to preserve evidence that will be critically important later. And let me give you some examples. You're involved in an accident and there's going to be a dispute about who had the red light or who crossed into whose lane. Well, an attorney will immediately, when I'm called with a significant accident, I will go out and hire an accident reconstructionist. And that is someone, oftentimes a retired police officer or accident investigator or retired engineer, who will go to the scene of the accident, and by examining the pavement or the area around the accident, they can find clues or indications of what happened and therefore piece back together who was at fault. For example, when there is a significant collision between two vehicles, that will usually leave on the roadway gouge marks where they can look at it and say, oh, the impact occurred right here. And that's on this side of the yellow line, so we now know whose lane it occurred in. And that doesn't match up with what one of the persons is saying about, well, they came into my lane. No, you came into mine. So an accident reconstructionist can go out, document that kind of stuff, gouge marks, burn marks, scrape marks, the debris field, where the debris is located, oil trails. They can document all that. If you allow time to pass, that evidence disappears.
I guess you want to see the car too.
Yeah,
Sometimes they get towed away.
Well, and a good accident reconstructionist, most cars have within them what's called an ECM module, which is an electronic control module. We call it a black box, though it's not like a black box on an airplane, but it has some similarities in that it records certain data for so many seconds prior to an event that triggers an impact event. So you can, based on the time of impact, if you download that ECM module, you can determine how fast they were going, what the throttle position was, meaning did they have their foot on the accelerator, did they not? Did they have their foot on the brake? When did they apply it? How many seconds prior to impact? That is critical information. But if the car is continued to be driven after the accident and you don't download it, that information can sometimes be overwritten and vanish forever. And that's critical information.
Do you find that the cameras that some people put in their cars play an important role in some of this litigation?
Incredibly important. I have a case right now where a woman was stopped in traffic on an interstate highway. She stopped in traffic and an 18-wheeler fails to stop and hits the back of her car at a high rate of speed, and she's now a paraplegic. The person that was originally behind her had a front and rear dash cam.
Wow.
And so we could see from that dash cam, we could see her vehicle and that she was stopped in traffic. We could also see the 18-wheeler approaching, and we could count the seconds where traffic was stopped, and he continued to come, and he continued to come, and he continued to come, and he never braked. And it was so threatening that the person whose car the dash cam was in, that was behind my lady, saw he was coming and said, "Dude, you better slow down." And he pulled over to the shoulder, and then the truck hit my client.
Wow.
Without that evidence, it would have been much more difficult to determine, the calculation. We could see that for 9 seconds, he had a clear view of my client and he never applied his brakes. We could see all of that information because of the dash cam. So after I got that case, I went out and bought dash cams for the members of my family, and we have them in our cars now.
Okay. What is UIM coverage?
So UIM coverage is coverage that is offered to individuals by their own insurance company called underinsured and uninsured motorist coverage, which protects individuals in situations where they have been injured by the negligence of somebody who either has no insurance or has insufficient insurance to cover their damages. And it's very useful for those situations because a lot of individuals are injured and they incur medical expenses that are above and beyond the minimum limits, which is $30,000 in Texas. And then they're in a position to where if the tortfeasor now has a minimum policy, they're kind of stuck. So it is always, I advise my clients to get that coverage because it is worth it and you pay for it and you shouldn't be afraid to use it, that your premiums are going to go up. It's what you paid for it.
Well, it's not terribly expensive either.
And it's not, no.
But I think you raise an important point. In Texas, as I understand it today, everyone who drives is supposed to have liability insurance. But not all liability insurance is the same. And so some people have a real cut rate policy that just barely satisfies the statute.
Well,
Okay.
and it's estimated that about 25 to 30% of drivers on the road at any given time don't have insurance.
Wow.
They let their premium lapse, they don't get the coverage, whatever. And when you think about $30,000, of the people who do have insurance, most people have the minimum that they have to have, which is $30,000. Well, if you're in an accident and you go to a hospital and you spend 3 or 4 days in a hospital and maybe you had to get there by ambulance or by care flight, you're going to be past $30,000 right there.
Kern, when someone thinks they have a personal injury claim and they want to come see you, what do you want them to bring with them?
Well, if they have photos of the event that caused their injury, that's always helpful. Even if it's not photos of them sustaining the injury, just the location, the situation, where it occurred, what the different viewpoints of it, so that as we're mapping it out, we can say, I was standing here, they were there. That gives me a good idea. Also, to the extent they've already obtained medical treatment, if they can bring maybe their diagnosis sheet or the notes from their last office visit. So that gives me an idea of, number one, who their doctor was, what their diagnosis was, what kind of symptoms, what kind of complaints, that kind of thing. And then if there's a police accident report, that's very important for me to have. That identifies who the other driver is, whether or not they have insurance, what kind of vehicle they were in. And that's enough information right there for me to get an accident reconstructionist started doing an investigation. So that's probably the base information that I would like to have.
One of our viewers is asking, should I just wait until the pain goes away to see if it's going to go away? If I'm hurting, should I just wait and see how long it's going to hurt?
No. No, I think if you are involved in an accident, then you should always take care of yourself first and make sure that you are okay, because a lot of times I have clients who say, well, I felt fine after the accident, I was a little shook up, and then days later, after their adrenaline has kind of relaxed, then they're starting to feel this pain, and Then they feel uneasy about going to a doctor 3, 4, 5, even a week later after the accident.
You know, Andy's question brings, if I might,
Yeah.
brings up a good point. A lot of people will say, I'm hurting, but I think it'll just go away, and so I'm not going to go to a doctor. First of all, if you're hurting, you need to go to a doctor to get checked out. If nothing more than you get the peace of mind of knowing you don't have something significant going on that's going to get worse. So you've potentially stopped anything from getting worse that occurs. But also, you need to understand that the insurance company on the other side is going to use that against you if you delay in going to a doctor. They're not going to thank you for being a tough guy that was conservative about your care. They're going to use it against you to say, aha, that shows you weren't hurt, and any complaint of pain you have now, you're lying about. So you need to protect yourself and document your physical condition by going to the doctor. Now, I'm not saying don't go frivolously if you don't need to go to the doctor, but you need to get that peace of mind to make sure nothing is going on that's more serious.
Well, Kern, one of your areas of particular expertise is in dealing with injuries you can't see, brain injuries, soft tissue injuries. And I think there's a lot of folks that'll say, well, I don't see a bruise, you know, I just don't feel like myself, that sort of thing. Am I being a wimp if I run down to the doctor or if I call a lawyer? What are your thoughts on that?
We have developed a lot of awareness in recent years about concussions and brain injuries. Through the NFL and players who get concussions, and now they've established a concussion protocol because they don't want you to play with a concussion. We recognize how serious that can be. There was a large settlement between the NFL and players who had been not taken seriously in their complaints about concussions. A concussion, by definition, is a brain injury. It's an altered state of consciousness, which the Center for Disease Control uses as the definition for a brain injury. And then that brain injury can then be classified as mild, moderate, or severe, depending on a bunch of other factors. And you do not have to have a loss of consciousness, complete loss of consciousness, to sustain a brain injury. You can just have that dazed feeling. You've seen the commercial where the football player is sitting on the sidelines and he says, "I'm Batman." You know, he has an altered sense of consciousness.
Right.
And that is a brain injury. Statistics tell us that 85% of brain injuries or concussions, mild brain injuries, will clear up in 30 days. The problem is that other 15% that goes beyond 30 days, that's what they call the miserable minority, meaning you're in the minority because most of them clear up, but yours didn't, and it's miserable when it doesn't go away. And those symptoms can then last months, years, or even be permanent. And that kind of an injury can be seriously debilitating. You look fine, but you can't remember things. You can't find words when you're trying to communicate. You're searching for words. You do what's called perseverating, which is when you get one thing in your mind, like a subject, and you just can't seem to get off that subject. You keep focusing on it. You know, you're just perseverating about thinking about this one thing over and over. Your mood changes, your personality changes, you're irritable, your family says you're not the same as you used to be. Those are all symptoms of a brain injury, which I always liken, it's like an iceberg. You know, you see a little part of the iceberg above the water, but the part that sinks the ship is down below the water, and it's unseen. And that part that will really impact your life and your relationships with other people is unseen. You can't see it on the outside, but that person's just not the same anymore. And those kinds of injuries can be helped if you get therapy and rehabilitation. But if you're sitting at home saying, well, I don't see anything wrong with myself, I'm not going to go to the doctor, you're not going to get better.
Was it fair to say that with any kind of injury, promptly addressing it is better than ignoring it till it gets worse. I mean,
I would think so.
if there's something wrong, I'd certainly want to know it as soon as possible, so that the doctors would have the opportunity to assist me before it became debilitating. Anna, how many of these cases actually go to trial?
Actually, a small percentage of my litigation cases will go to trial. All cases, when you file a lawsuit, you're given a trial date, typically from the county that you file in. And most of them can settle anytime between the start of the lawsuit and mediation. And mediation is when both parties, both the plaintiff and the defendant who you've sued, will meet with a neutral third party to try to get the case resolved. And in an effort to save costs of what trial costs, usually they settle there. But they can settle at any time, even past mediation, if the case doesn't settle then. So not a lot of cases go to trial, but that doesn't necessarily mean that because your case goes to trial, that it's any less valuable because it didn't settle at mediation.
Do the judges generally require mediation before a final trial in your types of cases?
Almost always, unless the parties have pretty much staked out their positions where they've told each other there's no point in going to mediation, we're going to fight this all the way, in which case we'll tell the judge, look, we're both experienced lawyers, we're telling you mediation would be fruitless. Even then, they require us to go to mediation,
Right.
probably more times than not. Because think about it, the county's got to call jurors in, it's got to pay them to be there. The judge and the bailiff and the court staff, all of those people have to do certain work to make a trial go, and none of them want to participate in that if the case could have been settled if you just get the people to sit down and talk about it. So everybody wants to avoid that waste of resources when there's an opportunity for a settlement.
And over the last year, juries have been a little hard to come by. Okay, we're just now starting to see where some of the courts are opening up again. I practice in family law, and the courts uniformly require mediation before they'll give us a trial. And I try to tell my clients that mediation is their opportunity to put together a better resolution, because nobody knows the case as well as they and their attorneys. If you have a trial, we'll spend a week, 2 weeks educating the judge or educating the jury about what happened and when it happened and why and what the law is. And the parties and the attorneys have generally figured that out. There's some areas of disagreement, but I have found in my area, and I'm curious if it is in your area, that mediation is prone to success.
That depends. That depends on the sometimes the insurance company that's involved on the other side. There are some of them who have basically developed a policy that they're going to try all these cases just to be cantankerous and to try to teach the plaintiff lawyers a lesson, and in doing that they think that it will somehow reduce the number of claims that are being filed, and therefore people will realize there's no easy money and they'll just go away. It's a bad philosophy and it doesn't work in my experience, but sometimes there are people who really don't want to resolve the claim in mediation. I still think, well, at least in the cases I handle that are significant or catastrophic cases, there is usually too much at stake to not go to mediation, because those cases can sometimes be talking about millions of dollars in damages. Why would you not try to resolve the case before you go down and let 12 people that neither one of you control decide what the outcome is going to be? I've also found mediation can be very productive in cases where the clients have at least a psychological need to be heard. They want to have their moment where they get to talk and say what they're upset about, and they need to just be heard and get it off their chest.
Very therapeutic.
It is. It can be very cathartic that once they've expressed that, they'll sometimes say, you know, I'm good. I can resolve the case now because I feel like I've been heard.
Mm-hmm. Okay. Anna, we have a question from one of the viewers. Skylar's asking, why and when should I get a personal injury attorney?
As soon as you can, after you've been involved in some sort of trauma or accident where you've been wronged or injured by somebody's negligence. As soon as possible, because you want to be protected, like we discussed earlier, from insurance adjusters that want to get in as soon as possible and get your version, but kind of in their own leading way. And you always want to be protected because your interest is not their interest. So you want somebody on your side to fight for you and get you the most that you can.
I would guess that for some folks, let's say they get hurt at work, they may not know whether they should be filing a workman's compensation claim or a personal injury claim. Is that the kind of person that should really just give you a call?
Right, yeah, there's a lot of things to discuss when it comes to work injury cases because it is different. You want to maintain your job, but you also want to be taken care of. And if your employer does not offer workers' comp benefits, you do still have an avenue of recovery, and at least should reach out to a personal injury attorney to discuss those options.
How many of these types of cases get settled before the lawsuit ever gets filed?
A lot of cases do settle before a lawsuit even gets filed, and that's taken into account a lot of things as well. Who you're dealing with, the type of insurance company that you're dealing with. Some are more amenable to settling before a case gets into litigation because of costs, as opposed to other insurance companies that really it doesn't matter to them whether a case gets filed or not. So a lot of cases do settle before filing a lawsuit, but again, it doesn't mean that your case is any less valuable because it did not settle.
Would you be talking, for example, automobile accidents where no one was really badly hurt, but you have the property damage to deal with and maybe some lost wages, things like that? The smaller cases?
In those instances where you have only property damage and maybe some lost wages, it may be easier to settle pre-litigation because you don't really have a lot of damages. If somebody who has been injured, it may take them 5 months to treat, and then we have insurance adjusters who are fighting about the cost of medical care and how it's excessive or unnecessary. It will preclude those cases from settling before having to file a lawsuit.
Kern, should folks see a doctor after they're injured before they come see you, or would you prefer they wait till they talk to somebody?
No, I would say go see a doctor immediately if you've got an injury. I think it would be foolish to wait to get the lawyer's advice because I'm not a doctor, nor do I play one on television. So no, you need to take care of yourself first and foremost, and we'll worry about the lawsuit later.
What would be your response to an insurance adjuster who says, you don't need a lawyer, we can take care of this ourselves?
Well, first of all, I know from experience that sometimes adjusters will use that, I'm your friend, I can help, why do you want to hire a lawyer? They're just going to take part of the recovery and we can work this out. You got to remember that insurance adjuster is not your friend. They are there and they are often compensated based upon how low they can resolve your claim for them. So they have a self-interest to try to take care of their company and themselves first. You are secondary. So you need someone in your corner to make sure that's not occurring. Also, I know of situations where the insurance adjuster will consistently say, we just need a little more information. Get this for me. And they put you off and put you off. And then that statute of limitations, which is the deadline to file the claim, runs, and all of a sudden they don't return your calls anymore, or they do just to say, guess what, you missed your deadline, you can't sue us at all now. they will actually stall you into missing that deadline.
Let's talk about that deadline, because I don't think most people are aware of the statute of limitations on filing a personal injury case. And frankly, there could be more than one. Isn't that right?
Yeah, the statute of lawyers get a little nervous talking about statute of limitations, because if I don't know the specific facts of your case, there's no way I can be 100% sure I'm telling you the right statute.
Right.
You might be the exception to the general rule. But generally, in Texas, there's a 2-year statute of limitations for a case that's a tort claim, a negligence type claim. If your personal injury claim involves some very specific other circumstances, it could be as short as 1 year, or it could be extended to 4 years.
Right.
But generally, the vast majority of the cases I work on, it's 2 years from the date of injury,
All right.
or the event that caused the injury, I should say, even more importantly.
We have a question from Bree. Anna, Bree's asking, why do I need a PI attorney when I get into an accident?
I think Kern said it perfectly. You want somebody in your corner to take care of you when you have insurance adjusters who are not on your side, try to talk to you or convince you, or try to offer you something that you may feel is unfair.
It's been my experience too that even if the insurance adjuster knows that you deserve to be compensated, the insurance company is enjoying the interest and dividends that are being earned by the money while it's still in their account. And sometimes payment is really slow. It's to their benefit to delay things. Isn't that right?
That's absolutely right.
What if the insurance company denies my claim?
Well, very often it happens where insurance companies will deny their claim for many reasons. For liability issues is a main issue that they will deny liability on, saying, well, it wasn't our insurance fault, rather it was your fault as to why the collision happened. Or they may deny liability because maybe they haven't received all of the facts or haven't spoken to their insured. That's why you do want to get an attorney involved, because those words may seem daunting to some people, denial of your case, but that doesn't necessarily mean that you have no case. In fact, you very well may have a case, but the insurance adjusters just want to throw you, aside and get rid of this claim.
Many years ago, before I had gray hair, I actually worked for insurance companies. That's how I started out, was working for insurance. And I didn't last long in that job for a number of reasons, one of which I'm about to tell you about. I had an adjuster one time tell me that his philosophy was, deny them all. Half of them will just go away. They'll just give up and go away. And we'll save enough money on those claims that we can then deal with the other half. So a lot of times, if not most of the time, the denial of your claim is not based on whether or not you're right or wrong. It's like it's a test to see how persistent you're willing to be.
Mm-hmm. Here's an interesting question that someone had written in about, saying, why aren't we suing the insurance company? And it does seem like in a lot of instances, both parties have insurance carriers. Both parties, it's as though the insurance companies are fighting each other. And both insurance companies have their own agenda. So how do you look out for your client in those circumstances?
Well, the first part of your question about why aren't we suing the insurance company, in Texas, you're not allowed to sue the insurance company. You sue the person. Their insurance company is not named, but that insurance company will come in and provide their defense and generally control the litigation, but they're kind of hidden behind the curtain a little bit, standing behind the person that's being sued. Some states, like Louisiana, for example, has what's called direct action. I wouldn't sue Anna, I would sue her insurance company, and the lawsuit would be me against her insurance company if she
Okay.
and I were involved in a. I think that's more fair, but Texas has a real fear of people knowing that insurance is involved because they're afraid, well, that'll cause people to just give bigger verdicts since they know that little old lady on the other side's not the one paying it if they know it's an insurance company. The
Well, that
problem
could be grounds for a non-suit or a
mistrial.
mistrial
It-
if the word insurance even gets mentioned.
if it gets mentioned in any way, shape, or form, the judge will declare a mistrial and you'll start over and with a new jury that doesn't know insurance involved. The reality is, though, that in recent years during tort reform, they made so much propaganda put out there about the poor insurance companies. And this is going to raise your premiums if you give money to someone in a car wreck lawsuit, that I think it would actually benefit the insurance companies to have it direct action because then they could claim more. So this is going to make everyone's premiums go up.
Right.
That's a lie. It's a fraud. It was a sham.
It's a boogeyman.
But it worked very well.
Mhm. Well, let me ask both of you, how should a person choose a personal injury attorney? You know, we have a question from a viewer. Are all attorneys the same? How do I choose the best attorney for me? And there are attorneys who specialize in certain areas, and there are attorneys who take it whatever walks in the door. I've done 3 of those cases in my career, this type of thing. How should a client choose an attorney?
Well, I think the clients should look into their website, see how many cases that they have or how, many times they've gone to trial. I think that as far as experience and interviewing going, go talk to these attorneys and ask them questions and feel free to get information from them because you're the ones that are choosing. It's your life, it's your case, and you should be the ones in control. So it's always important to ask questions that you're unsure of and make sure that the attorneys that you're choosing are well versed in the law and what's best for you.
In significant cases where it's a big injury and it's going to be hotly contested, I also think whether or not an attorney is board certified is an important thing to consider because board certification, there are approximately 100,000 attorneys in the state of Texas. I know that not all of them do this kind of work. Some of them work for government industries or contract lawyers or whatever, but there's about 100,000 attorneys in the state of Texas, and there's only about 7,000 of them that are board certified. So that really narrows it down, and board certification requires that attorney to have demonstrated so many years of experience, number one. Number two, years of experience in that particular area, whether it be civil trial law or oil and gas law or family law or criminal law, and they have to have tried so many cases in that particular area. Then they have to have taken a test that less than 50% of them pass.
Right.
Lawyers that have practiced in that area for years, half of them don't pass the test. So board certification is a very rigorous standard. So I think that's can be. I'm not going to say all the time. I know some attorneys who are great attorneys who are not board certified.
Sure.
But it's a good narrowing down factor. And the other thing I would say to people is, if you want the other side to take you seriously and to take your case seriously, you can't have a cartoon character for a lawyer. And what I mean by that
The
is,
arm waivers.
well, there are people who have developed a reputation for themselves that is cartoonish.
Yes.
And you have to know when you go to court with that person, the first thing that's going to pop into the juror's mind is that's not a serious person, and therefore your case appears less serious, in my opinion.
But he has really entertaining commercials.
Yeah.
Well, I try to tell folks to think about this. None of us are doctors, and I don't know how to pick the best doctor. And unless you're in the field and you can say, hey, Brother Bill, who's the best neurosurgeon in Dallas? We're all kind of out of luck, okay? And so the only thing you can kind of look to is their credentials. to say, well, okay, he is a specialist in this area. That tells me he has a passing familiarity with this area. And it's a good starting point to find attorneys. Now, for some cases, there are some cases that older attorneys and more experienced attorneys have had experience with that just by virtue of their tender years, the younger attorneys haven't had the opportunity to work on as many of those varied cases. Now, there are some cases, for example, Kern, that only a handful of attorneys in Texas really work on the brain injury cases. It's a startlingly low number. And it seems to me that is almost a specialty niche insofar as the evidence is so different. And you have to have the experience in dealing with that and explaining it to the jurors who may not have any medical training. So, when you're dealing with brain injury cases, what do you do differently?
I do a lot differently. The first brain injury case I handled that was a significant case was in 2008, and it was a woman that I knew actually from my church who was involved in an accident and sustained a brain injury that greatly impacted her life. But the accident itself wasn't a huge impact. If anything, there was small damage to the car because she was hit at an angle that caused her car to spin and then impact the concrete retaining wall. But there was a dramatic change in her personality, her work. She was a translator. She got to where she couldn't read, she couldn't concentrate, she couldn't find words, that kind of thing. In the course of handling that case, I read everything I could find about brain injuries. And then I spent a lot of time with neuropsychologists, neurologists, and some experts in the field of brain injury. And so I just kind of developed, and I was fascinated by it, and read all these studies. And we went and we tried her case. It was a 3-week-long trial. We got a great result for her that changed her life, and we were able to put that money into a trust where it continues to take care of her. But because it was the unseen injury where people would look at her, the other side said she's faking. She's lying, she's faking. This is not. They hired a private investigator to follow her and to see if she was doing things that were inconsistent. I learned in that so much about brain injuries that kind of became a focus for me, and I got another case and another case and another case and another case, and it just kind of developed where that was an area that I became focused on and I saw the same themes over and over. Does the MRI show an injury? Well, no, because most MRIs cannot go to a resolution that will show an injury to an axon, a dendrite, or a neuron, which are the parts of the brain.
Right.
So, average attorney who doesn't have that experience in a brain injury case will go, oh, well, your MRI was clear, so you don't have a brain injury. Sorry, let's move on to something else. And they don't know, no, we need to send you to get a diffusion tensor imaging exam done. That's a different exam, and it looks for a different thing.
Right.
So that kind of familiarity helps you in those kinds of cases where it can be critical.
Do you find that other attorneys refer those kinds of cases to you because of your experience and expertise in that area?
Well, I hope it's because of that, but most of the cases I get that are brain injury cases are referred to me by other lawyers. It's been the vast majority of. Once in that first case, when the trial went on for so long, it got a lot of attention. It was a big verdict. Matter of fact, it was the biggest verdict ever in that court. So it got a lot of attention.
Right.
And so as a result of that, people started referring me those cases.
Anna, someone has written in asking, what should I do if I'm involved in a hit and run accident? Would you handle that any differently than any other accident?
Yeah, in some accidents where both people stay on the scene, you typically exchange insurance contact and insurance information, and you can both go on your way. sometimes you do need to call the police when both people are still on the scene, but especially you want to call the police when you are involved in a hit and run accident, so you can document the fact that you were hit at this location at this time on this day. So when you even make a claim on your insurance for uninsured motorist coverage, you have this documentation to support that you have been involved in a hit and run accident.
Okay. What types of damages are compensable?
Damages and personal injury actions are usually divided into two categories: economic damages and damages. I describe economic damages as calculator damages or receipt damages. Those are damages that you can look at a bill, you can add up all the bills, you have receipts for them, you can calculate them with a calculator. For example, even your future lost wages. I usually hire an economist who can do an analysis and say, after taxes, you would have earned this much money over the remainder of your life that you can no longer work. So those can all be calculated with mathematical precision. Those are your economic damages. The non-economic damages are the things like pain and suffering, physical impairment. I can no longer use my leg. What is that worth? Well, you can't put a calculator to that. It's
Right.
it just depends on how you used your leg before, and you get 12 jurors who assign a value to that just based upon their common experience and sensibilities. We've had periods in Texas where, one political party will be in control versus the other. And they'll talk about tort reform, and we've got frivolous lawsuits, and we need to restrain the damages. But what's interesting is, no matter who's in control, the liberals or the conservatives, they've all agreed those damages, the economic and the non-economic, should be compensable. It's just what's right. So being conservative doesn't mean you're against the awarding of non-economic damages, because even the conservative legislature said, yes, those are entitled to be compensated.
Well, and if you're going to need care for the rest of your life, there's kind of no way to get around that. Here's an interesting question. Most people don't truly understand this, but what happens if I'm partially at fault for the accident?
Well, that does come up in situations where you are at trial and the defendant is alleging that the plaintiff who has brought the lawsuit is contributory negligent in causing the accident. And if they present enough evidence to the jury, then the judge may allow for that question to be in the jury charge, and whether the jury can consider the plaintiff partially at fault. And what happens in those situations is that a jury can put some fault on the plaintiff if they find that the plaintiff was contributory negligent. And in the state of Texas, if the plaintiff is even 51% at fault for causing the accident, then they recover nothing. It is only when they've either found that the plaintiff was 0 to 50% contributory negligent that they can recover.
Okay, so let's say that I'm 30% negligent. Yeah, I was responsible for the accident 30%. I didn't keep a proper lookout for something. But the defendant was 70% responsible. What happens then?
Well, then the amount that the jury determines you were damaged, both economically or non-economically, that defendant is responsible for 70% of that. If they were 70% at fault, they have to bear the burden of 70% of those damages.
Okay. Couple of general questions. Whiplash. Is that compensable? And really, what is whiplash? Just to be clear.
So whiplash is just when your head just makes a fast movement from side to side or front to back, and it is a injury that is compensable. You may need to seek treatment for that, and you may also suffer cervical strain, cervical sprain because of the way that the muscles in your neck have moved in such a fast period of time. So it is one of those injuries that is unseen in an x-ray or an MRI. So a lot of people say, well, you just got whiplash, but it is still an injury and it is still compensable.
Does whiplash, or can whiplash, last very long?
It can. If you've had severe whiplash, it may last several weeks, it may last several months, and it may come back on occasion where you have aggravating circumstances that a year later something happens and you feel that pain again. That all originated from this one event.
All right. Kern, you were discussing economic versus non-economic damages. How do you handle pain and suffering? We've all known folks who have an accident and they are in excruciating pain for an extended period of time, to the point that pain management becomes necessary to prevent the injury from aggravating. You've seen people who are twisted and because their body is trying to avoid the pain. How do you handle a pain and suffering issue like that, or the problems associated with pain management?
Well, first, pain is real and pain is debilitating. Pain is what keeps you from doing things that you would otherwise normally do. So I tell clients that they should be sure, tell their doctor about their pain, rather than saying, I don't want to be a whiner.
Right.
Well, that's great that you feel that way, but if you're feeling, number one, your doctor can't fix it if you don't tell him about it.
Mm-hmm.
And it might be an indication of other problems that your doctor needs to know about. If your pain shoots down the back of your leg to your calf, well, that may be indicative of a herniated disc. And if you're just trying to be a tough guy and not tell your doctor, you're only hurting yourself. So number one, you need to tell your doctor about it so it can be documented in your
Take your wife with you. And when the doctor says, how are you? And you say, fine, she will say, no, he's not.
That's right. That's right. My grandfather used to go in and my mom would say, did you tell the doctor about this? And he'd say, no. Well, why not? Well, he's the doctor. He's supposed to find it. No, it doesn't work that way. You got to tell them about your pain so it can be documented and addressed and become part of your treatment. Then as an attorney, one of the things I recommend for people to do is sometimes keep a journal. Keep a journal after your accident. Wednesday, can't sleep, up all night hurting. Thursday, tried to pick up little Johnny. I just couldn't do it. Saturday, Johnny wants me to play with him on the floor. I couldn't do it. Or I did it and I paid for it all day Sunday, and I regretted it. Keep a journal of those things so that you can build that chart later of what that evidence is. I've also had cases where the pain or the disability from the pain is so significant. The only way to really understand that for me was to spend time with my client. And the brain injury case that I told you about earlier, I lived with that client for 3 days so that I could see what her daily life was like. And I saw things that I would have never thought to ask about as just normally in an office interview. Mm-hmm. I saw that when she got up, she had to spend so much time doing this or doing that before she could even get dressed, and so I tried to walk in her shoes, right, so that I could truly experience the kind of disability that her pain and her symptoms were causing her.
Do you find that day in the life type of evidence like that is helpful in trial?
Indispensable, absolutely essential.
And I know there's some people out there who are saying, well, I'm not working, it's been in the pandemic, okay. How can I show that this has really impacted me? It's not like I can show that I can't go to work anymore. I'm a housewife, okay? And can a housewife be compensated for injuries that make it difficult for her to do her normal activities during the day, taking care of the kids, bathing the dog, the whole bit.
Absolutely. I think that's also very invaluable in trial when you have somebody who's explaining that, sitting on the witness stand, explaining how their life has changed. And that's when also journaling is really important, so they can remember the little details that otherwise would have been forgotten. And I think a lot of parents especially take those years of when their kids were young as so important and so special, and it really affects them when they can't be there with their kids. They can't play ball with them. They have a kid who's asking them, well, Dad, why can't you play with me? They don't understand that the parent is in pain, and that's why they lack that interaction. So it is important to journal, and it will be very invaluable to have that discussion on the stand in front of a jury.
There's always a couple of folks who say, I don't need a lawyer. I'll file this myself. I see that in divorce all the time. I'll just file it myself. I've watched enough TV. I know how to do this. What would be your advice to anyone contemplating trying to file a personal injury lawsuit on their own?
I think it was Shakespeare that said a person who represents themselves as a fool for a client. It's a dangerous thing to do. The law is very specialized, and there are a lot of procedural trips and traps that are built into things. If they send you a set of requests for admissions and you don't understand what they are, and you put them on the desk and you say, I'll deal with that next month, and 30 days passes, you've just ruined your case. Mm-hmm. Because at 30 days, if you haven't answered them, they're automatically deemed admitted, and they may have something. Admit this was all your fault. Admit you were lying about your injuries. Admit you killed John F. Kennedy. Right. Whatever. And just by not answering them, you have legally admitted to all those things. So, or if they file a motion for summary judgment, you have so many days to file a response. If you miss it, you're done. Your case is thrown out. In a medical malpractice suit, if you don't give a statutory notice, Chapter 74 notice, so many days before you file suit, not only is your case thrown out, you owe the doctor his attorney's fees. There are a lot of landmines in there to avoid.
The court is required to treat the person who's representing themselves like an attorney, which puts you at a terrible disadvantage given that the judge can only consider admissible evidence. Even if they want to hear what happened, if you can't present it in an admissible fashion, which is a trick, they don't get to hear it. And you really end up hurting yourself. One last question here is low property damage accident really worth getting checked out by a doctor or a personal injury attorney?
I think absolutely. If you're feeling any sort of pain, it is important to take care of yourself. And something that I always like to tell the juries is that we've all driven by that catastrophic accident and we see people walking away fine, and you think, that's a miracle, everybody's okay. They're walking out of this fiery accident, but you also have the opposite where there isn't a lot of property damage, but people aren't okay. So that's also possible to have significant injuries, not a lot of property damage.
Kern, if there's someone, we've only got a couple of minutes left, if there's someone out there trying to decide whether they need to contact you or not, what would you tell them, and how would they get in touch with you?
Well, if you're unsure, the worst thing that can happen is if you call me, I may say, I don't think I can help you, or I don't think you need me. So it doesn't hurt to ask.
Do you charge anyone for calling to
Nope.
check it out with you?
No.
Do you, Anna?
No.
So it's a free call?
It's a free call. And again, I'm not paid unless I secure a recovery on your behalf. So if I don't take your case, there's no charge. If, whatever, the calling and inquiring is a smart thing to do.
And as I said when we began, all of us work for the law firm of Bailey & Gallion. We're a consumer law firm here in the Dallas-Fort Worth and Houston area. We handle all kinds of cases. I handle family law. Anna and Kern specialize in personal injury litigation. And you can call and get an appointment at Bailey and Gallion for free, no charge, and sit down and talk to a lawyer and find out if we can help you. Or, you know, a lot of folks come in and see us, and we'll tell them, you don't need a lawyer today, you just need to take care of X, Y, and Z. But it's a free interview. We're even open on Saturdays. We try and work with you, and we take video interviews these days. That's kind of a big deal to not have to get up and go downtown and walk amongst a whole bunch of people. So we try and make it as easy for you as we can. I want to thank the Legal Cafe for letting us shoot here today. As I said, it's a workspace built by lawyers for lawyers, adjacent the courthouse, and so you can take your office with you when you go to trial. And if you need to meet with your witnesses, etc., it's a worthwhile endeavor. We hope you'll stop by and see it. It's at 114 Main Street in downtown Fort Worth. That's it for the Legal Hour. Thank you very much.